on Gender. Dr. Rallonza is an associate professor at the Department of Political Science, Ateneo de Manila University. She's currently director of the Gender and Atrocity Program of the Asia Pacific Center for Responsibility to Protect. Our fourth discussant provocateur is Dr. Candelaria. She will look at the implications of the proposed law on education. Dr. Candelaria is currently the Associate Dean for Graduate Programs at Ateneo de Manila Loyola Schools. She was the former director of the Ateneo Center for Education Development and has worked with various school communities around the country over the past 2 decades. Finally, our fifth discussant provocateur is Attorney Ricardo Sunga III, who will talk about the implications of the proposed law on human rights. Attorney Sunga is a special procedures mandate holder of the United Nations Human Rights Council. He is a member and former chair rapporteur of the United Nations Working Group of Experts on People of African Descent. Our provocateurs are given 10 minutes each for their presentation. Dr. Oreta, you can take the floor now.
Thank you, Diana. My task this morning, actually, hello everyone. Just to mention that there are quite a number of participants in this roundtable discussion. We now have 268 members or participants in this discussion. My task actually is divided into two. So I will be discussing the context as well as the security implications. So to begin the discussion, because I don't have much time, 4 assumptions or 4 arguments. I have 4 arguments in this presentation. Number 1, the terrorism threat is real, but our legal framework to address or handle the issues of terrorism is inadequate. The security institution and other critical state institutions have compromised credibility, and the timing of the passage of the bill is quite off. And I will go through these 4 points in my presentation. Okay. Now, this slide just shows you the major organization or major groups that have reported to have pledged allegiance to the AISEAS. Now, of course, the lines here are just attempts at representation, but I just wanted to show you that majority of these groups that have pledged allegiance to AISEAS are located in the Mindanao, in the island provinces area. Now, take note that the Raha Sulaiman movement was created by a former OFW who created this who was radicalized and created this organization and allegedly operates in Luzon area. Now, just to continue, the Philippines, as of 2018, in terms of the data, as of 2018 data, 23 groups have actually been or have been reported to have pledged allegiance to AISEAS. In Malaysia, there are 12 groups, and in Indonesia, there are 30 groups. So in other words, again, the point is that the issue of terrorism is real and the threat is real. The problem with the Philippines is that we have a weak border. Particularly in the what we call the Sulu Triangle, we do have quite a problematic management of borders here. Plus the fact that the political and security institutions, especially in the Basulta area, Basilan, Sulu, Tawi-Tawi, it creates actually a very fertile environment, not just for safe passage, but also for hiding. So sometimes we call them the safe havens of some local and foreign terrorists. The ethno-national connection based on language, religion, customs of people in the Philippines, Malaysia, and Indonesia actually facilitate ease of connection. Now take note in this diagram here, this is allegedly the route taken by the foreign fighters when they joined the Marawi siege. So that's why it was a major issue, or the weak border management was a major issue, especially during the Marawi siege. Now, the nature of the terror organizations has mutated also. You know, we call it the hybrid, or they are engaged in what we call hybrid warfare, meaning they are armed, they engage our security forces militarily, but they are also engaged in what we would say winning the hearts and minds of the people. No? So they're engaged in political and community issues in order to generate support from the community. And unfortunately, you know, the armed group is being engaged by the military, but when they do the winning the hearts and minds of the people, the question is who will address or who will handle or who will engage them in this regard. Now, what has been the response? No? On the international level, you will see here just some of the major treaties that has been forged by the United Nations over the years. Now, I didn't include anymore here the United Nations Security Council resolutions, but the point that I just wanted to make here is that there had been a lot of treaties internationally that has been formulated in order to address the problem of terrorism. On the part of the Philippines, we have enacted the Human Security Act of 2007. Now, take note that this Human Security Act has never been, has been implemented only twice. No? The first one is to use, the first time that it was used was to proscribe the Abu Sayyaf organization as a terrorist organization. The second time that it has been used was against a person who was involved in the Marawi siege. But it was actually settled out of court. So in other words, this law, this Anti-Terrorism Law or the Human Security Act has not been fully utilized. You know? So in other words, it's not, we don't have a strong anti-terrorism law because the Human Security Act actually has not been utilized precisely because of these three major points here. No? Number one, it has very strict requirements for investigation and surveillance, no? And it actually has harsh penalties against malicious prosecution. Now, this is well and good if you are suspected. No? In other words, if you are not a terrorist and you are suspected. So this provision actually is good to protect the rights of the individual. But in a situation where you are going after a terrorist, but you just fail to do a comprehensive case build-up, then it becomes problematic. No? So an acquittal, and this is the major reason why it has not been implemented. No? An acquittal on the terrorism charge would require the authorities or the apprehending authorities to pay 500,000 pesos a day. So that means if you detain a person for 30 days, so that's 500,000 times 30 days. So no, the police and the military has never attempted to use this law precisely because of fear that they might be penalized to pay, or their institution might be penalized to pay this 500,000. Now, another feature of the Human Security Act is that law enforcers are given 3 days for warrantless arrest. Again, from the point of view of human rights and the point of view of the suspects, this is good. No? But from the point of view of the security forces, they feel that the 3 days actually is limited, especially if you are doing case build-up or gathering evidence against the person or the organization. Now, the third major point on why the Human Security Act has not been fully implemented is because of this point. No? Surveillance and investigation require prior approval from the Court of Appeals. No? And if the Court of Appeals grants the request, the person that is being investigated must be informed and be allowed to challenge that in court. No? Again, okay, if you're a suspect and you're not guilty, but you are simply suspected, this is well and good. But if the person that is being investigated, for example, is a high-value target terrorist leader, then it becomes problematic if you still need to inform the person that you are actually conducting surveillance investigation against him. No? Now, in 2017, we had the Marawi. No? Marawi was really a wake-up call, no? Because of the inability or because the Human Security Act was inadequate in addressing a lot of the problems that was posed in Marawi. We also realized after the Marawi that there really is no comprehensive national action plan dealing with terrorist organization. The policy directives of national government and local government are conflicting. For example, national government would say we don't deal with terrorists. But if you go to local government units in, for example, in the Basulta area, they do have programs for the rehabilitation of terrorists who have surrendered. No? So you have that kind of dilemma or conundrum between the national and the local. And then, as I have mentioned earlier, border control in the Sulu area is extremely weak that actually allows the entry of foreign fighters. So in the absence of a strong legal framework, clear guidelines, and comprehensive security plan, what happens is that local government actually adopts ad hoc arrangement and project-based short-term programming and implementation of intervention. And more importantly, in the situation like this, military solution becomes normalized. Now, going now to the anti-terrorism or the implication of the anti-terrorism law, proposed anti-terrorism law. The proposed law, again, 5 major points, no, will equip, no, major implication of the law is that it will equip the state forces with a stronger legal framework. No? And these are the so-called highlights of the law. Number 1, instead of 3 days, it expanded the day of pre-trial detention to 14 days. No? Now, take note that these 14 days is not actually unique in the Philippines. You see here the number of days or the period that different countries use in their pre-trial detention. Now, the second point, no, that with regard the strengthening of the legal platform of state forces is that it expands the coverage to include acts of terrorism outside of Philippine territory. The current Human Security Act actually cannot be used for Filipinos who join ISIS abroad because it has no provision that actually penalizes Filipinos joining international terrorist organization. The third is that it strengthens the Anti-Money Laundering Act or the Terrorist Financing Provision. It clarifies on who is finally in charge of terrorism, and that is the Anti-Terrorism Council. And the law actually attempts to address the hybrid nature or the changing nature of terrorist organization through what we call a whole of government approach. The law, however, will not solve the failure of governance, no? Or the reason why some members get recruited in terrorist organization is precisely because of the bad governance or the dysfunctional governance or failure of governance in some area. The law will not address that. It will not improve our border management problem, particularly in the Sulu Sea. And it will not guarantee that the case build-up capacity of our authorities will actually improve. Now, and this is my last slide, the major challenges of the law. No? If you look at the provisions, no, there are always ways on how to strengthen the human rights or the possibility of abuse. We do have the implementing rules and regulation, or we can file cases in the court. But I think the major problem is that the credibility issue of the security institution and the justice institutions who will handle or who will be the primary in charge of implementing the law is actually problematic. No? They have a problem on credibility. Second major problem is that terrorist acts, no, remain, or the definition of terrorism remains problematic. There's no internationally agreed definition of what is a terrorist. So for example, if a security guard hostage or engages in a hostage situation, that is a crime. But if it is Nilon Hapilon, for example, or Sahiron of the Abu Sayyaf, who conducts the hostage situation, then it becomes now a terrorism problem or an act of terrorism. So when do we say that it is a criminal act and when do we say that it is a criminal act? That actually is a major dilemma with regard to the law on terrorism. the terrorist groups that or the issue that is being used by terrorist groups to recruit remains, no, the dysfunctional governance or the bad governance practice of some LGUs, no, especially in vulnerable areas for recruitment. And finally, and I think this is the major conundrum, no, we do need a legal measure, no, to address terrorism and to address the issue of terrorist organization. But at the same time, considering, as I have mentioned earlier, when do you distinguish between a criminal act and a terrorist act? When this law is used against individuals, then it becomes individuals who are merely suspect or critics of the government, then it becomes a draconian measure. So the problem always is that the state, the dilemma of distinguishing a criminal act and terrorist act is always the central issue that we are looking at or that we are problematizing in this proposed law. So with that, I end my presentation and I pass on now the floor to Dr. Abao to look into the institutions or the implication of the proposed law on institutions.
Apple, can you hear me now? Diana?
Yes, Melay. Yes.
Okay.
Yes po.
All right. Okay. Okay. All right. Good afternoon, everyone. Thank you, Apple. As mentioned, I will be sharing some thoughts on the implications of the Anti-Terrorism Bill on institutions. Reference that I used for my analysis, so to speak. Firstly, the definition of institutions that I use is that of Douglas.
Melay.
I chose this definition. Yes?
Nagchichapi ka.
Okay.
Okay.
Okay. Again? Should I do it again?
Yes, please. Yes, please.
Okay. All right. Okay. So firstly, the definition of institutions that I used is that of Douglas North, a political scientist. He defines institutions as humanly devised formal and informal constraints that structure political, economic, and social interactions. I chose this definition because it suggests that institutions matter, because they shape behavior and interaction. And because these institutions or constraints are humanly designed or devised, then they can also be humanly redevised or redesigned and changed. Power dynamics thus come into play. It will take some level of power to either maintain the constraints or to change the constraints that shape behavior. So I think this definition is very useful, not just for those who want to analyze political behavior and interaction, but also for those who seek political and social change. Secondly, a number of substantive provisions already suggest how the proposed law will impact on institutions. Section 2 states that the state will fight terrorism through a comprehensive approach. We can thus already predict that the state will mobilize different types of institutions, political, economic, diplomatic, military, legal, etc., in the effort to stop terrorism. Sections 4 to 14 are about the bill's definition of terrorism, what constitutes terrorism, and who can be considered terrorists. These sections suggest who are likely to be at the receiving end of this policy. Given those starting points, I suggest going through different levels of analysis and asking at least 4 questions. For my presentation, I will focus only on the first question and briefly touch on the second and third. The fourth question will have to be answered some other time, but I just want to flag it here. The first 2 questions ask which institutions and who are going to be mobilized and or empowered by the bill, and which institutions are going to be demobilized and or disempowered. Referring back to the definition of institutions, we need to examine the constraints that the bill mandates and how these are likely to shape behavior and the interaction of people in relation to human security concerns. After examining which institutions will be mobilized, we need to ask, so what? What is likely to happen if these institutions will be mobilized or For this, we need to historicize our analysis and examine the track records of these institutions. Finally, we need to ask how much. I flagged that question because this bill, if passed into law, will require resources. And given the COVID pandemic, we need to ask, shouldn't we be prioritizing resources for public health concerns instead of anti-terrorism concerns? All right, this slide shows all the institutions mentioned in the bill and how they are to be mobilized. I have classified them based on the roles and functions as articulated in the bill. And I have identified 4 roles and functions: policy and leadership, frontline, assistance, and oversight. The first one is the policy and leadership role. This is lodged in the Anti-Terrorism Council, or the ATC. The ATC will be the lead authority and the coordinative body, the clearinghouse, so to speak, for all government efforts against terrorism. As such, it is empowered by the bill to do many things, the most important of which are: 1, to plan anti-terrorist programs and actions; 2, to designate who is to be considered a terrorist group or person; 3, to authorize the arrest and custody of suspected terrorists without warrant for at least 14 days; 4, to request the AMLAC or the Anti-Money Laundering Council to freeze the assets of suspected terrorists; 5, to mobilize pertinent government agencies and even private institutions such as telecom and internet providers and banks and financial institutions to assist ATC's efforts; and 6, to coordinate with and answer to institutions that have an oversight role over government's anti-terrorism efforts. So, the ATC is very powerful. The bill obviously tries to downplay this immense power of the ATC by saying that the ATC will not be making decisions arbitrarily, and that in fact, its decisions and actions should be in accordance with the UN Security Council resolutions. It has to rely, for example, on the UN's list of terrorist persons or groups. But then again, the bill also says that the ATC can go ahead and can go beyond this UN list and make its own list. As per Section 45 of the bill, the ATC will be composed of 9 people. If it were to be organized today, the 9 would be the following. Chairperson will be Executive Secretary Medialdia. Vice Chairperson will be National Security Advisor Esperon. ATC members will be Secretary of Foreign Affairs Locsin, Secretary of National Defense Lorenzana, DILG Secretary Anyo, DOJ Secretary DOF Secretary Dominguez, DOJ Secretary Guevara, ICT Secretary Honasan, and AMLAC Executive Director Racela. Moreover, the ATC Secretariat will be the NICA, the National Intelligence Coordinating Agency, now headed by Director General Monteagudo. So the ATC is really President Duterte and his men, literally men. The ATC thus means more concentration of power in the office of the president. And we need to remember that some of these men were responsible for the coming out of that bizarre and incredible matrix of drug pushers and drug lords a few years back. These agencies and leaders cannot even come up with a reliable list of drug pushers. Do you really think we can trust them to come up with a list of terrorists? The second role and function is frontline work. Needless to say, this has been given to law enforcement agents, our military and police. They will be doing the surveillance, the arrests, and the investigations. The AMLAC, meanwhile, will be investigating and freezing the assets of suspected terrorists. Because of these functions, these institutions are also very powerful, but their power will be limited only to what the ATC will allow. Given the track record of our law enforcers, we need to ask, are they capable and professional enough to deal with terrorists? And aren't these the same people who terrorized thousands in the anti-drug war, especially in the Tokhang campaign? There are no indications that this anti-terrorism war will be any different from the anti-drug war in terms of possible abuse and excesses. There are, of course, provisions in the bill that say erring and abusive law enforcement agents will be made answerable. But we know how this goes. Bringing abusive law enforcement agents to court and then to jail is the exception. It is not the norm. The third role is assistance. Many institutions are expected to cooperate with the ATC and the law enforcers. Emphasis on many. NTC, apparently for wiretapping and online surveillance, DOJ, DFA, detention facilities, DOST, DOTR, DOLE, Dept, DSWD, PAPRO, I think that's the peace advisor, BARM, the NBI, the OCD, the ISAF, the CHED, the NCMF. Okay. I can understand the NBI and the ISAF being part of the list, but the Dept and the CHED, what do school kids or university students have to do with terrorism? And DOLE, why? So they can identify the terrorists among the workers or terrorists among the employers? Okay. The final role is oversight. In this regard, the regional trial courts, the Court of Appeals, and the Supreme Court are mentioned in the bill. But the most prominent is the Court of Appeals. The bill says that the ACT has to seek judicial review of arrests or requests for surveillance, detention, etc. with the Court of Appeals. But then the bill also says, go to the court only after 14 days of arresting suspects, and after that, you may even add 10 more days. The Commission on Human Rights, the CHR, also has a role. It has to be notified in case there is a warrantless arrest, and quote, should prioritize prosecution of violations of civil and political rights of persons in the implementation of the law, unquote. But then again, we know that this government views the CHR as an obstacle and not as a fiscalizer. The Joint Oversight Committee will be led by the chairperson of the Committee on Public Order of the Senate, that's Senator Grace Poe, and the House of Representatives, Representative Narciso Bravo, and 5 members of each house chosen by the Senate President, that's Senator Soto, and the House Representative, that's Representative Cayetano. So let's take a second look at these bodies. Can we expect the courts to have the capacity and political will to go against the wishes of President Duterte and the ATC? We know Duterte has the numbers in the Supreme Court, and he is the appointing officer of our judges. Can we expect the CHR to speak against excesses? Yes, most likely it will, but can we expect the CHR's actions to really make any difference? And the Joint Congressional Oversight Committee, we already know there is a supermajority. So these guys are most likely just going to be saying yes to whatever the ATC will say. So who will be doing oversight vis-a-vis the ATC, the frontliners, and the assistants, and the assisting institutions? The answer is nobody. This in itself should tell us that this bill is very dangerous. Now, in terms of who will be demobilized, I think the first to be crushed will be the CPP, NPA, and the F. I wouldn't even be surprised if government pushed for this bill mainly to crush the NPA. And then, of course, there's the rest. Yellows, opposition political parties, social movements, students, workers, trade unions, indigenous peoples, of course, schools and universities. Here I have some examples. Yes, kasama ang Ateneo, and of course, media. Think of the following activities. Anti-mining protests, labor strikes and pickets, urban poor defending their homes against demolitions, farmers defending their lands, government employees protesting against corruption, students protesting against tuition fee hikes, journalists advocating for press freedom, priests and nuns protesting against extrajudicial killings, feminists protesting against President Duterte's misogyny. Now, imagine these activities under this anti-terrorism law. We all know that protest activities could get ugly and could bring harm to people and property. If and when they do become ugly, will these activities then be considered terrorist? Political and social institutions critical of government and or public policy are thus easy targets. But then again, these institutions can also choose to strengthen themselves against possible crackdown, like what the institutions did during the repressive Marcos regime. To close, let me leave you with 3 points. 1, we can expect that the institution of the presidency through the ATC and the frontline and assisting agencies will be made even more powerful because of this bill. 2, no oversight is likely to happen, and there won't be checks and balances. 3, given points 1 and 2, expect more human rights violations and more abuses and excesses, and don't expect the terrorism problem to be solved. Thank you. I now give the floor to Dr. Binet Rallonza.
Okay, so the thing that I'm actually going to walk you through is with regard to the Anti-Terrorism Act of 2020 and thinking about gender. So in the onset, I would like to declare that gender matters. In fact, gender inequality has always been observed as an indicator in places where terrorist actor thrives. Curiously, gender stereotypes, norms, and dynamics are usually implicated in anti-terrorism laws, policies, and programs, and yet, according to the Center of Human Rights and Global Justice, little or no attention is paid to it when examining the differential impact of counterterrorism to men, women, and sexual minorities. Now let us look at the proposed law. First is in terms of what is written. The text. The text of the proposed Anti-Terrorism Act of 2020 is gendered. On the one hand, there was an attempt to be gender inclusive, albeit very binary, through the use of he, she, his, her pronouns in Section 11, foreign terrorist, Section 15, penalty for public official, Section 27, preliminary order of prescription, Section 29, detention without judicial warrant of arrest, Section 30, rights of a person under custodial detention, although not very consistent in its use, Section 32, official custodial logbook and its contents, and Section 34, restriction on right to travel. However, it's very curious as well that most of the attribution of the gender is actually pertaining to the suspects. On the other hand, when you look at Section 19, effective period of judicial authorization, Section 20, custody of intercepted and recorded communication, and Section 42, infidelity in the custody of detained persons, the pronoun used was actually he. And these sections are actually referring to state actors. The odd mix was Section 30, or the rights of a person under custodial detention, that used he when talking about person charged or suspected of a crime, when informed of the nature of cause of his arrest, and the right to counsel of his choice. They only used his and her when they're actually going to inform the suspects of their rights. In other words, all of these sections, or all of this articulation in Section 30 are inconsistent in terms of gender language. Taken together, one can say that the text presupposes gender of possible suspects as well as state actors. And in that sense, you have the text as quite gendered. Second, Melai already spoke to you about the ATC, but Section 45, or the Anti-Terrorism Council, really talks about the institutional body responsible for the implementation of the law. She already identified to you what are these various offices. You have the Executive Secretary, you have NSA, you have the Secretaries of Foreign Affairs, National Defense, Interior and Local Government, Finance, Justice, Information and Communication Technology, and Anti-Money Laundering Council. And by the ones that are actually occupying these positions, as also mentioned, are all men. Section 45 also stated that the National Intelligence Coordinating Agency would serve as the Secretariat. Currently, the top leadership of NICA are men. Lastly, Section 45, who also mentioned the following support institutions: the OST, the OTR, DOLE, Dept, DSWD, PAPRU, BARM, NBI, BI, OCD, ISAP, and PCTC, PNP, SHED, and NCMF. Of these 15 agencies, only one, namely Dept, is headed by a woman. This is to say, therefore, that the ATC is highly male-streamed and by implication would likely implicate the male perspective. But other than that, they are not only men, they are also men with more power. Third, you're talking about protection. And in that sense, I would draw your attention to Section 51, which is actually protection of most vulnerable groups. And let me quote what was stated there. There shall be due regard for the welfare of any suspect for elderly, pregnant, persons with disability, women and children while they are under investigation, interrogation, or detention. End of quote. This section includes women as part of the vulnerable groups that need to be protected. But from what? There are several puzzles here. First, The title of the section speaks about protection of vulnerable groups, but the text pertains to suspects with certain attributes, being of advanced or young age, pregnant, with disability, and gender. Second, protection is equated with due regard for the welfare while they are under investigation, interrogation, or detention. How do we operationalize with due regard, and how are these things actually related to the idea of protection? And third, this section somehow serves as a declaration that vulnerable groups, including persons with disability and children, may be subjected to investigation, interrogation, or detention. Why are they even there in the first place? Vulnerable groups or disadvantaged population under international human rights law, or IHRL, are usually those who experience systematic and even systemic violation of civil and political rights, as well as economic, social, and cultural rights. According to Chapman and Carbonetti, many of these groups experience discrimination, social exclusion, stigmatization, deprivation of protections and entitlements on an ongoing basis. Having a provision on terrorist suspects who are part of the vulnerable groups being ensured of due regard for their welfare because of having certain attributes is not protection at all. Vulnerable groups most likely fall victims to terrorist acts and less likely to actually perpetrate them. Counterterrorism measures are meant to protect the whole population from terrorism, particularly vulnerable groups, including women and LGBTI individuals who are regularly its victims. Let us now move on to what is not written in the text, or going beyond what is in the written text. Let me draw your attention to the Convention on the Elimination of All Forms of Discrimination Against Women, General Recommendation 30, that actually reminds us that the convention is a convergence, has a coverage to the application to include war against terrorism as a situation of concern that results into serious violations of women's human rights. The proposed law does not in any way guarantee that this configuration of war against terror will not lead to women's human rights violations. In fact, as many fears, there are quite a number of provisions to be discussed later by Attorney Sunga. Second, you have the mention of UN Security Council resolutions. United Nations Security Council Resolution 1325 is the mother resolution pertaining to the global agenda on women, peace, and security. 1373 is about the threats to international peace and security caused by terrorism. 1373 is gender blind. It has no reference to 1325 and made no mention about women's vulnerability in the context of war against terrorism, nor their contribution in fighting against it. In April 2019, Assistant Secretary General and Executive Director of the Counterterrorism Executive Directorate of the UN noted the growing recognition of the need to actually converge 1325 and 1373 to include gender considerations in all counterterrorism and CVE efforts. Additionally, she mentioned about women's role in countering and preventing terrorism, as well as differential impact of counter-terrorist strategies on women's human rights. UNSCR 2242 attempted to interface women, peace, and security with counter-terrorism and violent extremism by urging that gender be made cross-cutting issue within these agendas. The proposed bill, or the proposed law, refers to a gender-blind 1373. It has not taken into consideration the relevance of 1325, particularly women's participation in decision-making and policy implementation in peace and security efforts. No 2242, specifically on ensuring the participation of women and women's organizations in developing strategies to counter terrorism and violent extremism. In the same vein, it has not referred to the Philippine National Action Plan on Women, Peace, and Security 2017 to 2022, which could have guided the policy to adhere to gender-sensitive practices. In summary, from a feminist perspective, the proposed law is masculine as inferred from its text. The main body responsible for its implementation is also male-centric and most likely represent like-minded male thinking. And the provision of protection is quite a misnomer in its stipulation and thus creates a space for abuse for vulnerable groups, including women. Of course, this is not to say that the current text is when the current text is fixed to be more consistent in language, or if there are more women in the ATC, or the protection clause is rewritten to reflect genuine protection of vulnerable groups, the proposed law would magically be legitimate. Mentioning the agenda of women, peace, and security should not invite simplistic alterations of adding and stirring women in an anti-terrorism regime. In fact, women, peace, and security should not be commodified nor co-opted to serve the interests of the masculine agenda. In other words, from a women, peace, and security perspective, making armed conflict women or girl-friendly is not the point. The point is rather to address the conflict itself. In the same manner, referring to women, peace, and security or using a gender perspective to the proposed bill does not mean making it more gender sensitive. It means rather to invite actions to addressing drivers of terrorism themselves. Passing this law while we are in the midst of pandemic, of economic downturn, of massive unemployment, of double standards in implementing policies or preferential treatment given to political allies, or the rise of violence against women, including economic downturn and massive unemployment, of double standards and what have you, is ill-timed. The proposed law further divides and polarizes. It is a hegemonic script, nothing just being us versus them, and throws a veil akin to martial rule over legitimate dissent. For each and every failure, the institutional response seems to be more draconian measures, policing, monitoring, silencing, not even bothering to take responsibility, no fear of being held accountable, comfortably settled under the blanket of impunity. This is what strongman politics is all about. Yes, we are under a hyper-masculine state with an ever-increasing number of masculine policies instead of a state that commits to transformative leadership, good governance, social justice, sustainable peace, and human rights. I understand the need to protect people from terrorism, but first, define it as clearly and as comprehensively to deter it being used with unbridled power. Thank you very much. I pass it now on to discussion to Dr. Candelaria.
Thank you, Dr. Rallonza. All right. So let me begin. Okay, can you see now? All right.
Yes, ma'am.
Thank you. All right, let me begin my presentation with three assertions about education, schooling, and the school. First of all, education is not just an agent of socialization, but I would like to highlight that it is an agent of politicization. Following North's premise that institutions are humanly devised constraints that structure our interaction, our educational system can be seen as one that devises both the formal and informal rules governing our political behavior. Schooling, therefore, the formal process of being educated, is a very political process. And the school, the organization tasked to deliver formal education, is a site of power. So it then follows that education, schooling, and school is not and should not be a neutral process, nor a neutral activity, nor even a neutral organization. My second assertion is that the school, whether we're talking about basic education or higher education institutions, is a site where one's political values are tested. And when I say test, I mean it is where we assess our own political values with our classmates and teachers. We examine it, we try it out, we scrutinize our assumptions about political realities. The classroom is a dynamic but also a safe learning space where difficult and often controversial questions are asked and debate is encouraged, all in the pursuit of better human condition. It is a laboratory where critical thinking and evidence-based analysis of social issues and public policies are developed and sharpened. It is also a place where young people's political values are constructed. We learn by actively engaging with others inside our schools, not by memorizing the books. And so finally, for many of us, school is actually our incubator of community empowerment. It is a site where we learn to translate abstract democratic principles into concrete political actions. This is where genuine political empowerment is first felt by many of us and appreciated not only by students, by teachers, parents, alumni, and other members of the school community. It is in schools that young people learn to organize themselves and eventually organize their own communities to ascertain basic democratic principles of justice and fairness. And so what will be the implications of the proposed bill on education, schooling, and schools? The proposed act gives the executive branch through the Anti-Terrorism Council an overbearing power to determine what constitutes as quote-unquote serious risk, what is legitimate and illegitimate dissent, what counts as terrorism, who may be tagged as terrorists, etc. And so this power of the ATC as law enforcer, judge, and jury all combined not only sends a chilling effect to our students, our teachers, and the schools, but it also changes the purposes of schooling and the nature of education as an institution. So in terms of impact, I have here three. It's really, well, Dr. Abaw has mentioned that one of the institutions that is being demobilized now by the proposed law is actually educational institutions. And I'd like to say that, yes, that is a short-term effect, but I think we would like to really question the long-term effect of the proposed bill. Here, the school now becomes a site where ideas can no longer be debated, nor critiqued, nor strengthened, and that the schools become a factory where young people are molded in a certain quote-unquote acceptable manner to serve the interests and purposes of the state, whatever purpose it may be. It is quite unusual, for example, to see Dept, CHED, DOST, and I put here DOST as an educational institution because they manage the Philippine Science High School system, where many of our activists before, during martial law and up to now, are also thriving of this in a very progressive environment. These agencies were identified in the bill as agencies that provide assistance to the ATC. These three agencies, if you look at their enrollment in 2018, it's 31 million young people under all these three agencies. So we should ask ourselves, what sort of assistance would the ATC need from these educational agencies? The second, I think, is that the curriculum now becomes a tool that reproduces acceptable norms and behavior. In many countries who transition towards or away from democracy, one would almost likely see a shift in the way how social studies and civics education are designed, written, and taught. Curriculum development is political because it reflects the language and values of whoever is designing it. So academic freedom is not only seen in what we can or cannot do, or what we can and cannot say or write, but more importantly, academic freedom is also in our expression of what we ought to know and not how the government would tailor us to certain kinds of curriculum that are restricted in terms of these kinds of knowledge. It is not far-fetched, therefore, that if this bill is passed, the role of the teacher and the student changes. In this situation, teachers are expected to teach what is prescribed, and students are expected to memorize. Encouraging too much critical thinking may be misinterpreted as inciting to commit acts of terrorism, or what they are doing now, red tagging, or simply merely recruitment. So what reading materials now are safe? What questions can we ask in our classrooms that are considered safe? What are we allowed to write in our school paper for the campus journalists here in the audience? Is it still worth it to ask our students questions designed to provoke their minds, but may unintentionally anger the state? I think about how unfair this is to many of our public school teachers in particular who have to choose between livelihood and vocation. Section 15 of the proposed bill, for example, provides that public sector employees, which includes the more than 1 million public school teachers and faculty members of the various state universities, may be charged with administrative misconduct and or disloyalty to the country, dismissal from service, and forfeiture of retirement benefits, among others, should they violate this proposed law. And so finally, my third point is that education now becomes a political. It's an institution detached from the processes necessary to deepen and strengthen democracy. We should all be fine as long as what we teach, what we learn, what we say, what we ask, and what we write may not be understood by the state and its apparatuses as acts that incite terrorism. And so the question now is, why are we asking this "are we safe" question? Are the schools supposed to be the ones who's instigating all these critical questions so that the next generation could actually determine what is best for them and this society? So I now turn over the floor to Attorney Ricardo Sunga.
Good morning, everyone. My intervention is about the impact of the Anti-Terrorism Bill on human rights. In my humble view, the bill raises several human rights issues. Human rights are expressly guaranteed by the 1987 Constitution of the Philippines and in international human rights treaties, including the International Covenant on Civil and Political Rights, to which the Philippines is a party. Ratification transforms treaties into Philippine law. These treaties embody obligations with which the Philippines must comply. One human rights issue is the insufficiency of the notice given by the Anti-Terrorism Bill of the conduct that will expose an individual to criminal liability. People have a right to be adequately warned beforehand of the behavior that they should avoid. The insufficiency in the prior notice in this connection is contrary to procedural due process. The definitions in the bill of terrorism and related crimes, including inciting to commit terrorism, are overly wide and susceptible to various interpretations. They are vulnerable to abuse. Another issue is the curtailment of the right against unreasonable searches and seizures. For an arrest, as a rule, the Constitution requires a warrant from a judge. But the bill authorizes the Anti-Terrorism Council, an executive body, to designate a person as a terrorist for the purpose of arresting him or her without a warrant. For that matter, freezing assets may also proceed from such an executive designation. The Anti-Terrorism Council is made up of executive officials who are often moved by zeal in carrying out their duties. They are not judges who are expected to be calm, sober, and objective in their decision-making. Yet another issue is the violation of the right against arbitrary detention. The bill authorizes the detention of a person arrested without a warrant for as long as 14 days, extendable for 10 more days, before being judicially charged. This prolonged detention is inconsistent with the Constitution that limits detention prior to being judicially charged to 3 days, even when the privilege of the writ of habeas corpus is suspended. Being brought to judicial authorities for a determination of the propriety of the filing of judicial charges is an important check on the legality of a warrantless arrest and detention carried out by executive officials. The power of this check is diminished or lost in a prolonged detention. Next, the bill produces a chilling effect on the exercise of freedom of expression. The danger lies in the lack of sufficient standards in the bill as to who is a terrorist and the accompanying susceptibility of individuals or groups to be designated as terrorists by the Anti-Terrorism Council. The resulting heightened risk of arrest and detention creates fear and apprehension on the part of individuals and groups who may wish only to share their views and to air their legitimate grievances in the exercise of their right to free speech. If I may be allowed one more observation, behind the anti-terrorism bill appears to be a misunderstanding on the part of the authorities of those who have a different opinion. If I may ask, should we not welcome differing voices with diverse points of view? Should we not take steps so that everyone will be heard and nobody will be left behind? In the effort to achieve true and lasting peace and justice, the goal is not to suppress nor to discriminate upon any ground. Rather, it is to include and to empower, and always to ensure to the fullest extent people's human rights. I will end on these observations. I return you to Dr. Diana Mendoza, Chair of the Department of Political Science, our moderator today.